What is entrapment in criminal law? Explained. Have you ever wondered how someone could be charged with a crime they might not have committed without the influence of law enforcement? This brings us to the concept of entrapment. Entrapment is a defense used in criminal law when a defendant claims they only committed a crime because a government official, like a police officer, pressured them into it. The key idea here is that the defendant would not have acted unlawfully without this improper persuasion. In legal terms, entrapment has two main components. First, there is government inducement. This means that the crime was encouraged or instigated by a government agent through tactics like threats or manipulation. It is not enough for law enforcement to simply provide an opportunity to commit a crime. They must have crossed a line by using improper methods that essentially created the criminal act. The second component is lack of predisposition. This means the defendant was not inclined to commit the crime on their own before the government's involvement. In other words, they did not have the criminal intent independently and only engaged in the illegal act because of the government's influence. Entrapment is considered an affirmative defense. This means the defendant must prove their case by showing that it is more likely than not that the government's actions caused the crime. If they succeed, they may be acquitted since the law acknowledges it is unfair to punish someone who was essentially tricked into committing a crime. From a criminal defense perspective, entrapment protects individuals from abusive police tactics. It ensures that law enforcement does not create crimes by pressuring those who would not normally engage in criminal behavior. This defense helps maintain a balance between effective law enforcement and protecting individual rights. To successfully raise an entrapment defense, a defense attorney must present evidence showing that the government agent's actions were improper and that the defendant was not predisposed to commit the crime. Courts often look at the defendant's background, prior criminal history, and willingness to commit the offense without government involvement to assess predisposition. It is important to note that entrapment does not apply if a private citizen induces the crime or if the government merely provides an opportunity without coercion. The focus is specifically on government misconduct that exceeds legal and ethical boundaries during criminal investigations. In essence, entrapment in criminal law serves as a defense claiming that government inducement led a defendant to commit a crime they would not have committed otherwise. This legal principle protects individuals from unfair prosecution that arises from improper law enforcement conduct.